Hello, welcome to Law and Life Matters. I am your host, Masavala Mutimele, and this is season 2, episode 2. Today, in this episode, we are unpacking, understanding litigation procedures, alternatively, civil procedures. And to help us discuss this topic in detail, we have today a very special lady. Her name is Vitumelo Munyatsi. Now, I'm just going to read a little bit about Vitumelo. Vitumelo is an LLB graduate from the University of Witwatersrand. She obtained her degree in the year 2006. She is a litigation specialist and has extensive experience in the following fields of law: insurance, road accident litigation, financial services law, municipal law, and pension funds. She's also an overall litigation specialist. Vitumelo is the founder of BM Munyatsi Inc., a specialist litigation practice which she started in 2017. Hello, Vitumelo. Thank you for joining us today. Welcome to Law and Life Matters. How are you?
I'm very well, thank you. How are you?
I'm well, thank you as well. So litigation is a very high stakes and high action, well, most of the time, have aspects of legal practice. So I just want to find out, like, when people start a legal battle, what is the purpose of a letter of demand?
Okay, so a letter of demand serves several purposes. The first one would be to inform the other side or your opponent that you have a potential claim against them. You set out what that claim is, and then you also set up what you are claiming, so the amount that you would be claiming for them. In the letter of demand, you also then give them a time frame. For example, you'll say, come back to me within 14 days or 5 days. You give the other side an opportunity to read your letter and then come back to you, explaining or defending or just advising you what their next step is. So that's to inform the other party. There's also legislation that requires you to serve a letter of demand on your opponent before you litigate. So, for example, the Institution of Proceedings Against State Organs Act says that you can't go to court before you've actually served a letter of demand on your opponent, which would be an organ of state. And then also to claim interest, if you have a contract or an agreement and you say there that interest will be claimed from a certain date, then you have to serve a letter of demand so that the interest will then start to run. So it's got several purposes to the letter of demand.
I see. So can a client approach a legal practitioner and end up not going to court?
Yes. So even if a matter that goes to court is called litigious. A matter that doesn't go to court is called non-litigious. So even if a matter is litigious, when you approach an attorney and you go through the matter, you might find that you're actually able to settle or reach an agreement with your potential opponent before you actually start the litigation process. So there are quite a few instances where a client will come in and the parties are able to negotiate, so there's no need for summons, or summons is issued, and after that institution of proceedings, then the parties are able to reach a settlement, and then the matter doesn't proceed to court.
Okay, that's interesting. So is it completely impossible to start any legal action without a letter of demand?
It's not impossible. It's just it's safer to proceed with a letter of demand, because if you institute summons and you start during the course of the matter, when it gets to court, the judge or the magistrate will say, but you were supposed to issue a letter of demand. Then you can apply for condonation. So condonation is when you make an application to the court saying, please condone this behavior. I was supposed to have served the letter of demand. I didn't serve it, and I would like the court to allow me to serve it now. So they're condoning the non-service of the letter of demand.
I see. Can you please explain the issue of jurisdiction? What is jurisdiction, and what is the jurisdiction of our courts?
So jurisdiction just means the court's competence or the court's authority to hear a matter. So there's several grounds of jurisdiction. When you approach a court, you first check whether the court has jurisdiction based on where the cause of action arose. Cause of action means the incident or the thing or the issue that led to this dispute arising. So for example, with a car accident, if the car accident happened in Blackstop, Northwest, you can't institute action in Durban. So that's where the cause of action wholly arose, because that's where the accident happened. And then you also look at your defendant, where your defendant resides or carries on business. So you follow your defendant. If the defendant is in Mpumalanga and you are in Gauteng, then you would issue summons in Mpumalanga based on the defendant's residence or where he conducts business. And then with, for example, a contract, you would then look at where the contract was concluded, and then you would issue summons there. So when the court gets an application or a summons, they first look whether they have the competence or authority to hear the matter and give a judgment on the matter. But what also happens with jurisdiction is that parties can agree to a certain jurisdiction, for example, in an agreement. So if the parties are not in the same place, in the same area, they can say that if any dispute arises between us, we are choosing the Johannesburg Regional Court, or we are choosing the High Court in Johannesburg or Pretoria. So with jurisdiction, sometimes the parties can elect where they want to go. But basically, it is going to the court that is fit to hear that matter.
I see. So I heard you say something about okay, so you said parties can agree depending on the agreement. They can state in the agreement that, okay, we agree that if we have any dispute, the jurisdiction is going to be this particular court or located in this area. And then you also said that it can happen that if one party is in Klerksdorp, for example, the party that is being sued, then the jurisdiction of the court would be that way that the defendant would be. So I just want to find out your thoughts on that matter. Why do you think that is? Is it fair? I mean, imagine if I'm just trying to imagine if I'm the one who's trying to sue somebody, why do I have to go to where that person is? Why can't the law accommodate me in my area? Do you think it's fair, or how what is like the rationale behind that?
I think a lot of the rationale behind one of the reasons would be for certainty, because these are court rules. So you need certainty that we are only going to accept 1, 2, 3, so that it's not too broad where now jurisdiction is an issue and can you proceed and can't you proceed. When the rules are set out, then you know exactly what you're supposed to do, and it doesn't create any further confusion or wasting any further time. It's just standard. Whether it's fair or unfair, it's just the rules.
It is what it is.
It's what it is.
Yeah, okay. So I have a scenario. If, for example, Thabo and Gogezo, both directors of a company, they enter into an agreement to supply stock. So Thabo agrees that, undertakes that he will supply Gogezo with stock for maybe building supplies and in 3 batches, right? Now, and then it so happens that Thabo delivers the stock the first time, he gets paid. The second time he generates an invoice and gets paid as well. And then on the third occasion, he delivers the stock, but on this time, Kokezo does not then pay Thabo, even though Thabo has now generated this invoice and given Kokezo sufficient notice. So in that instance, right, when Gogezo suddenly becomes a bad payer and now owes Thabo 400,000, for example, how do you assist your client who would then be Thabo in this matter? Thabo comes to you and says, "Yo, this person has not paid me. This is what happened. I delivered stock, and on this occasion he has not paid me, and we have this agreement that he's supposed to pay me after an invoice." How do you assist your client in this matter?
So in that scenario, you would look at the agreement between the parties. What does it say if one party is in breach? So what does it say if one party doesn't perform, the one party doesn't deliver the stock, or the other party doesn't pay? So they get the stock and they don't pay for it. the agreement must set out what must happen, which would then be a breach. And normally, you would afford the other party a certain period of time to remedy the breach. So you would say, I've delivered the stock, I've delivered the invoice, you haven't paid, I'm now giving you 14 days, 21 days within which to pay the stock, failing which we are going to cancel this agreement, and then I will proceed to claim the amounts that are due to me. So then the other party hopefully will come back to you and say, I haven't paid because I don't have the money. Can I pay in installments? Or I'm only going to be able to pay you after 23 days. Please, can you just wait? Or they'll pay you immediately. If they don't pay, then that's when you cancel the contract and you issue the agreement and you issue the letter of demand, which is going to say that we entered into an agreement on such and such a date. In terms of this agreement, this is what I am required to do. This is what you are required to do. I fulfilled my obligations. You didn't fulfill your obligations. There's an amount of 400,000 outstanding. I'm giving you X amount of days within which to pay that amount, failing which I'm going to issue summons. And if the time period that you've given the other party then expires, then you proceed with your summons to claim the amount that is due to you.
I see. And so what happens when there is no written agreement in place between the parties? It was a verbal, just like, okay, we agree, handshake, I give you my word, and then they carry on like that, and then on the third occasion, Kogetsu doesn't pay.
Then you rely on the oral agreement and you say that on such and such a date, we agreed that I would do this and that you would do this. I delivered the first time, I sent you an invoice, you paid for it. I delivered the second time, I sent you an invoice, you paid for it. And then I delivered again, and now this time you haven't paid for it. In terms of the oral agreement, you said that you would pay, so now you need to pay. And if you don't pay, it follows the letter of demand process. If you don't pay, then I'm giving you a certain amount of days. If I don't get the money within that time period, then we are issuing summons to recover the amount due.
Okay. And so how would you advise a client who is going to consult a lawyer or an advocate for the first time to prepare themselves? Are there any documents that they need to carry? What do they need to put in order before going to see a lawyer that would help them make the first consultation very productive and smooth?
So different attorneys, I think, would approach it differently. What I always do is when scheduling a consultation, I will give client a list of all the information that we need. So we will need all the relevant documents. We will need a copy of your ID and your FICA documents. And then it gives us an opportunity to go through the documents before the consultation so that when we have the consultation, we have this information and then we just build on it. So the only documents that are really relevant are those that are relevant to the issue at hand. If there's anything else that would be relevant, then you would remind client before the consultation to please bring it because this seems to be outstanding. But basically, you just bring all the documents that are relevant to the dispute or the matter that the client is seeing the attorney about. The same would apply with an advocate. Remember, with our system, now we've got trust advocates, but with our system, the attorney briefs the advocate. Before you get to the advocate, the attorney already has a consultation with the client. So if there's anything missing, then the attorney will ask for it and then put it in a brief to counsel, so that by the time you get to counsel, counsel has all the documents that they need for that first consultation.
Okay. And so what are the time periods, or what time periods does a client need to consider when they have a litigation matter that is in the hands of an attorney? I know sometimes clients tend to get confused, like, oh, this is taking so long. Oh, why do we need to? So if there are any time periods that they need to maybe just consider, okay, there's a time period for this, there's a time period for this, or,
Yeah, I think the days, the time periods, I think they do get very confusing for clients. So what clients should, attorneys would then have an obligation to just inform clients at every stage that happens in the litigation process. So for example, after you get a plea, then you tell the client, we've gotten a plea, we need to look through it. The next step is now whether we reply to the plea or we close pleadings and go to the discovery stage. And then that will, and give yourself also time. So you'll say for a period of about 15 days, I'm not going to report back to you because I'm attending to these documents. Then I'll come back to you and we'll take the next step. So client will have an idea of what the dates are. They won't be to the T because things happen with litigation. So at least if they have some sort of indication that I shouldn't expect to hear from my attorney for 2 weeks, then they don't panic because they know that everything is still under control. So it's important to always communicate with clients throughout the process, just so that they know what's happening and they don't think that you've disappeared on them. I think the important dates would be dates where you need documents from clients. So for example, with discovery, you would then need more information from client, and then you would need them to sign the discovery document. So you would tell them that on such and such a date, I'm going to need to have a 30-minute consultation with you to go through this document so that you can sign it, and then we're taking it to court. When you get a trial date, then you say on such and such a date, we are going to court. So a few days before that, we need to prep for court. But you just keep them informed because it does get overwhelming, Yeah.
Okay, and so now we are on the stage where documents need to leave the office and there's a sheriff that gets involved. Please explain the role of the sheriff. Do I, as a member of the public, have to accept documents from a sheriff or sign anything? If, like, the sheriff of the courts approach me, here are documents, sign. What should I do in that situation?
So the sheriff is what's the correct word? It's the court official that serves documents. After the sheriff has served a document or has tried to serve a document, he then generates something that's called a return of service. And that return of service is a document that you then show the court that on such and such a date, such and such document was served at this address on this person at this time. And that's prima facie evidence that service was effected. So the reason we use sheriffs, number one, certain proceedings, the documents have to be served by sheriff. So those proceedings, for example, are like divorces, adoption matters, any matters that change your status. You must use a sheriff. And also instituting action, you use the sheriff. And then anything after that, the sheriff doesn't have to serve. The office messenger can serve. So the sheriff will serve. You don't need to sign anything. When he gives it to you, that's service. I think we get the signing notion from American reality TV, where this person springs up and you've been served, sign this, and then all that confusion. That doesn't happen here. So the sheriff will come to your work or come to your home and give you a document that's called service. If he comes to your home or your workplace 2 or 3 or 4 times, then there are alternative ways of serving. So he might not give it to you. He might give it to anybody at your workplace or your home who's over the age of 16. They can accept service. If there's nobody there, sometimes the sheriff will leave the document at your doorstep. And that's considered service. There's a recent case, I think it's December 2022, where the court held that the service was valid, where the sheriff actually served on the security guard of a residential complex.
Mm-hmm.
And the reason the court said this was valid is because they took into consideration that when somebody lives in a complex, sometimes it's very difficult to get in and out of the complex. And sometimes you go 3 or 4 times and the person is not home. But the security guard is over the age of 16 and he is employed by the residential complex security. So he was, in that specific matter, he was then considered an employee of the residential complex security. The applicant in that matter then said, but it's not proper service, and the court said, no, it is.
Yes, I remember that case. I think it must have been such a relief for legal practitioners as well, because in the past, that would be a return of non-service. So it would be as if the sheriff has not found anybody, he has not served, just because the sheriff did not find the defendant at the, like in the complex, there's like unit numbers, at the
Units.
exact
Exactly.
unit number 70 there, like, yo.
Yes.
So we really, I think everybody benefits from that particular judgment. I'll try
Yeah.
and find the judgment as well, and then just list it down somewhere in the subtitle, so that anyone can go and read it and refer to it if they so wish. Thank you so much for mentioning that judgment.
Yeah.
Mhm.
I was just about to say, we actually did a LinkedIn post on it just to advise clients and members of the public that your domicilium, whether you are there or not, does not change. So documents can be served on the security guard at your residential. So I'll also, if you need, I'll send it to you.
Okay,
because I've got the citation. I just need to look for it here.
Thank you so much. In practice, sometimes I would remember, like, you would have a situation whereby, if even though there's like a complex and the security guard who's there, who's the person that's over 16 years of age, sometimes the sheriff would have to like serve the document and just leave it there, like post it somewhere, leave it under a rock. Oh,
Yeah.
imagine the just how many things can go wrong in such a situation.
Yeah.
It rained on, some kids could come and just grab that rock and like, so really that judgment is a game changer. It's such a huge.
Yeah.
So what other options are available if a defendant cannot be located at their known address, but they are still in South Africa?
So serving on somebody whose address you don't know, that would be substituted service. But you need a court to give you permission to use substituted service, because normally you would serve at the address you have, and then the sheriff goes maybe 2, 3, 4, 5 times and they can't find them. Then you go back to court and you say, this is what we've done to try to serve this document on the defendant or the respondent. We can't find him at this address. The sheriff has been on several occasions. Please, can we then serve in a different manner? And then the court will say, that's fine. Then you proceed with substituted service. That could be in a newspaper. So if the last time you knew that this person was in this area, then you would find the local newspaper in that area, and then you would advertise the notice or whatever court process it is. Reason being that if it's circulated around the area, you're hoping that somebody who knows him or her would then alert them to what is going on, or that they might actually buy the newspaper and see that there's a matter that affects me and I need to respond to this court process. You can also serve by Facebook. You can serve by email, the last email address you had, or you can actually approach family members or friends and just say, look, we need to serve this document. We've served it at this address. We're unable to locate this person. Please, can you take this and make sure that he finds out about it? That sort of thing. So that's called substituted service, because you're not proceeding the normal way.
And are there any extra steps that an attorney needs to take in that instance, to prove to the court that, even though this has been substituted service, like, is there like maybe, I don't know, would the sheriff need to come to court and explain that this happened, or is there an affidavit that needs to be submitted to court in that instance?
So remember, the return of service is prima facie evidence that service was done. So the sheriff wouldn't need to come to court. As long as you've got that return, it shows that the sheriff has been to this address on several occasions. So in that instance, you're going to have more than one return with different dates and different times. And then you just need to show the court that we've taken all reasonable steps. We've even taken a few extra steps. And now we need the court to grant us permission to serve in this way. So Yeah, the extra steps, I suppose, would be I went on a Saturday thinking that maybe I would be able to find the person, or I went on a Sunday afternoon, or I went at 5 o'clock in the morning. That's normally before people go to work. So just show that you've taken all reasonable steps to try and find this person at this address. It didn't work, so you need permission to use a different route.
Okay. Okay. That's very thorough, and I think it shed some light for me because I thought maybe there's like an affidavit involved that needs to be submitted to the court as well in that instance, in the instance of substituted service.
So can I interrupt you there?
Yes,
So
please.
the affidavit, it's an application. So I think maybe that's why you're thinking about an affidavit. So the attorney is going to say, these are the steps that the sheriff has taken, and these are the steps that we have taken. So you will set that out under oath on an affidavit, and then you apply for a hearing date. It's going to be a motion, and then you go and remember, motion is on the papers. So you'll say, here are the returns of service to show what the sheriff has done, and then this is what I have done, and I swear under oath that what I have done is true and correct, and there's nothing more that we can do. So you're right, it's an application. It's not it's an application within the action.
I see. Sure. I think I'm very happy that the law gives us so many options to find somebody, to track them down. It's such a relief, I think, today to be able to serve somebody through substituted service via email, even on Facebook. I think that's also quite generous of our law. So now to flip the situation around. So now I've been chasing this defendant down, trying to locate him or her and serve them with summons. What happens in the instance where now I am served with a summons? What should a person do when they are served with a summons?
I think the first thing you need to do is get an attorney. The sooner the better, because remember, we've got time periods. And if you miss the time periods, then the implications are default judgments and all of that. So as soon as you get the summons, within like a period of about 3 days, 4 days, try to get an attorney so that you can have somebody who will explain what this document is, what it's saying, what it requires of you, and what you must do to defend it. So that at least you just know what the document is. And then after that, you'll decide whether you defend or not. But the first step is don't sit on legal besides a summons, whatever document you have that's a legal document, don't just sit on it and think it will work itself out. The chances are it's not going to work itself out. So when you get something and you don't know what it is, find an attorney.
And so what options are available to somebody who does not have the funds to appoint an attorney?
Okay, so there's legal aid, and you have universities have law clinics. So I know Wits has a law clinic. University of Johannesburg has a law clinic. I think most of them have law clinics where they are able to assist people who earn below a certain threshold. So those would be people who don't earn a lot of money, but make a little bit, and then they are able to help for free. I think it's for free. I haven't interacted with the law clinics in a very long time, but I think it's for free. And then they are able to assist with matters and legal documents and explaining what's happening.
Okay. So you mentioned that, if you ignore a legal document and you think, oh, it's just going to go away on its own, there are certain time periods that are regulating that process, and you could end up with a judgment, right? So what exactly is a judgment?
So judgment is it's a ruling by the court that says this is the status quo, this is the situation. So if you skipped a few payments and then there's a judgment against you, it means that there's like a mark on your profile. So we don't have blacklisting anymore, but we've got negative credit scoring. So it might affect like applications you make for loans and finance, but it's a record that says that you have not done something that you were supposed to do. It's an order against you.
And so, if I have a judgment against me, how can I deal with this? Does it mean I'm doomed for life? Is there a way that I can tackle this judgment, or how can I deal with a judgment that is against me?
Well, first of all, you need to know what the judgment is for, because you get a process called a rescission of judgment. So rescission of judgment is where you apply to the court for the judgment to be rescinded. So if let's just say it's for a debt and you've paid the debt, then the person that you owed would then give you a letter, which is a consent to rescission, saying, look, the judgment can be rescinded because the debt has now paid. At that time, I got the judgment because the debt had not been paid. Now it's been paid, so rescinded. And then you get a document that says rescission of judgment. So it depends on what the judgment is. You're not doomed for life. You can go to a court and say, the circumstances have not changed. At the time that the judgment was obtained, this was what was going on. I've now fixed the situation so the judgment can be rescinded, and then it gets rescinded. Yeah. I was about to say withdrawn, but it's almost like it puts you back in the position where before the judgment was taken.
I see.
Yeah.
And so is there a difference between appeals and a rescission of judgment?
So a rescission of judgment is where you say, this was the circumstances, I've remedied it, and now things have changed. An appeal is where you say a judgment was given, not all the relevant facts were taken into account by a court. So it's not the same thing. They're two completely different processes.
And so with an appeal, is that one of the ways that a person can take a judgment and say, no, I'm not happy with this judgment? Or do they just always have to like accept it? Okay, this is the judgment. And is there any other way that a judgment can be tackled besides appeal and
review?
Besides appealing the judgment and besides making an application for the rescission of judgment?
So a third way is to review a judgment. But you see, the thing is with a rescission, that's actually a very good question. With a rescission, the majority of the cases are where, so for example, like we mentioned, a summons is served on the security guard, and then you only find out about it after judgment has been taken. So then you go back to the court and you say, yeah, I didn't know this judgment. I didn't know the summons was served, and now there's a judgment, but I've got a defense to that. And I wanted the court to give me an opportunity to put my defense before the court. See, that's a rescission. Thank you. So the difference between appeal, review, and rescission, with an appeal, you are basically saying that you're unhappy with the actual judgment and you want it to be looked at again, to maybe get a different judgment. With a review, you're looking at the process. So you'll say that the process that was undertaken to get to a certain judgment was flawed. So for example, there may have been bias or certain of the evidence was not considered. So the actual process is the problem. That's with your review. You review how you got to the judgment. And then as advised or as explained with the rescission of judgment, this is where you want the judgment to be set aside because at the time the judgment was taken, X owed Y money, and now the money has been paid, so there's no longer a debt. So you rescind the judgment.
All right.
I hope that explains.
Yes, that is crystal clear.
the other thing also that we have to bear in mind is all of them have different grounds. So you have the grounds for your rescission, you have grounds of review, the basis on which you want to review, and then you also have grounds for appeal. So those grounds would be like categories, and you would then say, okay, I want a different outcome. So am I going to take a review, an appeal, or a rescission wouldn't come into play when you consider review and appeal? Because like I said, it's a completely different process.
All right. And so you've had years of experience in litigation. You have your skin in the game. So I just want to find out from you, what would you say makes a good litigation practitioner? What advice would you have to somebody who maybe wants to make partner one day in the litigation department at a law firm, or somebody who wants to go out and pursue litigation on their own in their own practice? What advice would you have for someone like that?
I think yeah, I would advise somebody to be quite even-tempered. Litigation is mostly an adversarial system. So there's a lot of combat on documents and in discussions and in parties trying to get what's best for their clients. So I would suggest somebody who's got an even temper, somebody who's not too shaken or stirred by things, because you have people saying their threats, sometimes they're insults, they shouldn't be, but it gets a bit charged at times. So if you have an even temper, if you enjoy reading case law, if you enjoy testing the law, because remember, litigation is where I put to you, this is my position and I think we are correct. You say, no, this is my position and we think we are correct. So if you enjoy testing the law and going to court and arguing, then litigation is definitely for you. And also just stretching yourself. Sometimes you think you know something, and then when you actually have to test it, you think, okay, maybe I'm not married to this approach or this idea. So I think that's the difference between litigation and other fields of law, is that you're always testing yourself and also always testing your knowledge and what you know and how you apply it. And it's interesting because when you specialize in a certain field, then most of your work will be in that field. So you get to be comfortable in what you're doing. But sometimes you get matters that are not in your field, and then you have to then really, really test your understanding and your application of the law to whatever the facts of the matter are. So you're always growing, you're always being stretched, you're always being challenged. So if you like that, then I think you'll be a very good litigation attorney.
Thank you so much. I also learned that in your spare time, you've recently taken to hiking and enjoying Pilates. So I just want to find out, is that a way for you to, does that create a nice balance for you in your life? And what other ways can you suggest that people who are in a position such as yours, in litigation, who are dealing with highly stressful matters, how do you suggest that they take care of themselves in instances like these?
I think besides just litigation attorneys, I think attorneys and advocates and legal practitioners in general, it is a very stressful profession. It's a very pressured profession. So you have to really take time out for yourself to recharge and not to be overwhelmed by what happens during the day. So find what works for you. For some people, it's baking. For me, it's hiking, because you get to get out of the city and just be in a place where you don't necessarily have to talk about anything or think about anything. For some people, it's sports, knitting. There's a lady who knits. Whatever it is, you have to find whatever it is that helps you to de-stress and to also just keep things in perspective. this is your job. It's a very important job, but you can't be losing sleep over your job. And, some people turn to other things and drinking too much.
Alcohol.
When it gets to that, alcohol, yeah.
The notorious one that we know.
So before it gets to that, just find whatever it is. Some people run marathons, some attorneys run marathons. Just find whatever it is that helps you to de-stress, and so that you're not overwhelmed by your workload, by demanding clients, by deadlines, everything else that goes with running a practice and also being in litigation. You have to take care of yourself.
Please, thank you. Thank you so much, Vuk'uzenzele. That concludes all the questions that we had for you today. Thank you for taking your time out and being so generous with your journey, with the information and your skills to come and share with us and whoever's listening today. We wish you all the best with the rest of your career and in growing your practice even further than it has grown. Thank you so much.
Thank you for having me.
And thank you at home for tuning into Law and Life Matters. We are grateful for your ears, for your time, and we hope that you'll tune in next time.
Thank you. Bye.
Bye.